A person was once introduced to another person as a lawyer, and then the first person responded, "Are you a criminal lawyer?" To which a third person interjected, "Is there any other kind?" Well, that's a rather cynical view as to the ethics of lawyers or the wrongdoing propensities, perhaps, of some lawyers. But I do think it's true that when most people think of lawyers, they often gravitate towards criminal defense lawyers and the work of prosecutors and those who are representing people accused of crimes. And there's nothing inappropriate about that at all. Criminal law is a focal point of the legal system. It is obviously a very significant area in terms of people's freedom and occasionally even their lives being at stake. It's so fundamental that when our Bill of Rights was enacted over 200 years ago, most of the provisions in the Bill of Rights have something to do, in fact, with criminal law. Our Constitution rests upon the notion that the power of the state is very, very strong, and individuals need a number of protections to counter the power of the state, to charge people with crimes, to bring the full force of the state into a court, and to end up possibly convicting and incarcerating those individuals. And that's really what so much of criminal law really is about. It's procedural in orientation. Yes, the substance is also important, but in many ways we already have a sense of what the substantive law is. A lot of that we really did learn even at a young age in terms of basic concepts of don't steal, don't lie, don't cheat, don't do harm to others. A lot of these concepts are in the substantive law. They're more elaborated. The elements obviously are much better defined than, say, what you learned from your third grade teacher or in your Sunday school. But it's really in the procedural law area where so much of criminal law really has a lot of bearing and a lot of import. And so what I hope for you is, as you're looking at various internet sites, you bear in mind that the reason for these protections under the Fourth Amendment or the Fifth Amendment or the Sixth Amendment or in various court decisions interpreting these various protections is because of this concern that it is much, much better for, as they say, 100 guilty men to go free than one innocent person to be incarcerated. That's the reason for these protections. That's the reason for the presumption of innocence. That's the reason why we are not to convict someone unless we can go beyond a reasonable doubt and are convinced that in fact this person is guilty. It's an entirely different sort of ballgame than what we have in most of the areas of law, where it's a much more even scale preponderance of evidence standard. And the reason for that is because we're so worried about the state having such overwhelming power, as opposed to, say, in the civil law context, where it's usually just private individuals slinging it out, and we are much more content to kind of let them go at it and not worry nearly as much about one side taking advantage of the other.